Hey guys, what is up? It's Dusty here, and welcome back to another crypto video. And a very scary document just came out from the SEC, which basically states that Ripple's requests to get documents about Bitcoin and Ethereum's verdicts are not relevant. This is very scary, and today we will talk about why and what exactly was discussed. Make sure you understand I am not a lawyer, nor is this financial or legal advice, but I think it is pretty damn interesting and pretty fun to cover. Having said that, we are giving away 250 XRP, and all you have to do is make sure you press the like button, make sure you are subscribed, and make sure you comment something down below. And if this video hits 1,500 likes within 24 hours, we are giving that away. So it's just 3 simple steps. That is all you have to do. And go check out GSX, a link is down below. It is the world's first gold-backed crypto, and there's just one more day of sale left if I'm not mistaken. So go check it out, link down below. Right now it is 10 cents a coin with a 5% bonus plus a 5% bonus for using my link, and I'm hoping that this coin can almost instantly take our money to the next level by going times 10, times 20, times 40, 50, I'm not sure, but that's just because it's the first of its kind. You guys know what I'm trying to say with that. It's a little bit of a risk. You never know if these things will pop off, but since it's a first gold-backed crypto and a growth coin, a new concept of a stable coin, I think there's a lot of potential in it. So that's again why I put a couple $1,000s into it. Link will be down below. Having said that, Ripple's requests for Bitcoin, Ethereum related documents are overbroad, claims the SEC. In their own literal words, they basically said, defendants request that the SEC search 19 custodians for both internal and external documents, and for documents related to Bitcoin and Ether, it would impose a disproportionate burden on the SEC to review a massive number of irrelevant documents. Wow, right? Wow. And this is not one little part. It's not like it's only one small argument. No, right? It's an 11-pager that the SEC just filed. Again, it starts off with relevant factual and legal background. Okay, that's interesting, but not too relevant for our cause here. The parties meet and confer process. Okay, once more, not completely relevant, not too interesting in my opinion. Here is where things get interesting. The requested Bitcoin and Ether documents are not relevant. Like, what is going on here? What are they talking about? Now, I think most in the crypto community right now are saying, let's wait for Attorney Jeremy to make a video on that. And I'm personally, even though of course I'm the content creator myself, so I like to cover it wherever I can, I will also be waiting for a video because some attorneys out there, there's most likely a couple, can just look through this, scout through this, read it, and know exactly what this means. Whenever I read this, and I've done that just now, all I'm getting is the SEC is trying to chicken out. Because basically, what they've said before is that XRP has utility. It's basically differed from Bitcoin and Ethereum because of its utility. But since Bitcoin and Ethereum were also mentioned by the SEC's attorney like a couple of days ago, I would say, well, it's quite relevant whatever is discussed. Also, from a different perspective, logically, anybody could assume that Bitcoin and Ethereum, the way that they have been decided basically, is going to be relevant for an XRP case. If XRP is involved, then it is very important to take a look at what was discussed basically with Bitcoin and Ethereum, yet they're saying it is not. So today, well, let's go read over this. If you want the TLDR, just kind of scroll through and I'll give you guys a heads up maybe, I'll put it in the comment section down below, maybe or in the description, what you should skip to if you don't want me to read it. But yeah, this document also here explains some of the most interesting quotes. Simply invoking comparisons to Bitcoin and Ether or labeling a digital asset as a currency is not cognizable defense. Discovery pertaining to Bitcoin and Ether can therefore have no bearing on the issues in this case, or at least is not proportional to the needs of the case, as Judge Hellerstein held in an SEC digital asset case. The aforementioned letter went on to claim that Ripple's requests in the matter are disproportionate, overbroad, and unduly burdensome. Not only do they demand irrelevant discovery, they also demand a highly burdensome discovery, including for internal documents that would require a significant privilege review. Yeah. All right, let's go cover it just a little bit. From point 3 on forward, if you want to read the rest, just quickly pause the screen here. You can read it for yourself. I don't think it is too relevant, though, for our specific case here. But, yeah, if you wanted to, you can quickly do that. All right, point 3. Defendant's opening argument, letter 2, that XRP is like Bitcoin and Ether, and therefore not an investment contract under the Howey test, has previously been made by other defendants in the SEC or Department of Justice security laws cases involving digital assets. Every court confronted with the argument has rejected it and instead applied the fact-specific Howey test. In this case, defendants' own statements to the market confirm that XRP is not like Bitcoin or Ethereum for purposes of security laws. In short, as the cases make clear, simply invoking comparisons to Bitcoin and Ether, or labeling a digital asset a currency, is not a cognizable defense. And for this part, I'm going to say that point 2 is a little bit relevant, as here they're basically explaining what Ripple calls XRP and how they are basically differentiating between XRP themselves and Bitcoin. However, if you're also talking about these documents, which are not really mentioned later on again, the SEC produced over 81 gigabytes of data, which consists of approximately 97,000 documents and 4,000 external emails. This is all for the first request for production of documents, and now they're putting up even more. At least Ripple wants more, which wants more is really understood by us. In this case, defendants' own statements confirm that they are different. In short, to make the case clear, simply invoking is not recognizable. Discovery pertaining to Bitcoin and Ether can therefore have no bearing on the issues in this case, or at least is not proportional to the needs of the case, as Judge Hellerstein recently held in an SEC digital asset case. Whether XRP are securities is a fact-specific inquiry. See Howey, yada yada yada, test is flexible in case of adaptation on the totality of the circumstances. It's a very big thing, but all right. Noting that under Howey, each case must be analyzed on its own facts. Facts about two digital assets that are not at issue in this case are irrelevant to the question here. Did defendants offer and sell XRP as a security? The focus is on XRP and Ripple, not on the other digital assets or the SEC. Consistent with Howey's focus on substance over form, courts look at all the representations made by the promoter in marketing the interests, not just the legal agreements underlying the sale of the interests, which is interesting. This analysis turns on the economic inducements the promoter offered, and the inquiry is objective, focusing on the promises and offers made. It is not a search for the precise motivation of individual participants. Applying that law, which is talked about here, under Howey, courts conduct an objective inquiry into the character of the instrument or transaction offered based on what the purchasers were led to expect. Applying that law, courts have uniformly rejected arguments that a digital asset is not a security because it resembles Bitcoin or Ether or labeled a currency. First, in United States v. ZLQZAA, the defendant argued that his digital token, Recoin, was a currency and not a security because case law recognizes that digital currencies function as a medium of exchange, mem of I, in sup of motion, to dismiss, yada yada yada. He further cited the SEC statements about the status of Bitcoin as a medium of exchange and argued that because Recoin's purpose to function as a currency, it was akin to Bitcoin, for which the only value lies in its ability to pay for things. Honestly, guys, it's already, until we've read here, very confusing because I do get what James is trying to put up, what the SEC is trying to put up here. It is basically the idea that Ripple has already kind of differentiated themselves as XRP of being different than Bitcoin and Ether is. And what has also happened is even if Bitcoin was classified something, it doesn't really matter for the case of XRP, because if a different crypto came up and said, well, because Bitcoin is not a security, ours isn't, that is a little bit of a strange defense, right? But a different degree, a case and a judge will always use different cases to build this one. So I would say there's similarities between Bitcoin and XRP, so it might be relevant. And I also have a video, but I guess I lost it somewhere. It is over on my profile here. I have a video here of, for example, the founder of Ethereum. It's right here from Digital Asset Investor. Also kind of talking about how there's crowdfunding and whatnot. And the bigger question pops up, what makes a coin a security now in the digital asset space? And is Ethereum relevant enough to XRP? I would personally say yes, because, well, they have kind of a similar background. However, they are arguing here and saying that there's multiple things that you have to look at, and every case has to be seen individually, yet saying that there's no relevance between them or it's not relevant at all, I would say is very odd. Because whatever way that I would like to view it, it is always going to stay relevant. Here they're talking about some of the previous cases, which are SEC versus Telegram and SEC versus Kick. I don't think they are too relevant to discuss here either because, well, honestly, We've seen those cases before, and honestly, they're so different than XRP is as well, so why really talk about them? The defendants in Telegram advanced similar arguments and repeatedly pointed to the SEC staff statements about Bitcoin and Ether to argue that Telegram's digital asset grams were not securities because they were intended to function as currency, yet they're calling that not enough to deviate from their current way of doing things. Because Judge Deary rejected the Recoin as a currency simply because it may function as a medium of exchange and made no comparison to Bitcoin in doing so. Instead, hewing to decade-old Supreme Court precedent, Judge Deary dismissed the arguments and noted that the label defendant chooses to attach the alleged scheme does not control the analysis. So, by you calling it a currency does not mean it is a currency, which is logical. If you're just calling something a currency, it doesn't mean it actually is. Yeah, I get that. Yet, in this case here, getting the documents over, that's still something that people can just request because it might be relevant. They're saying it's not because Bitcoin and XRP will be claimed, or sorry guys, analyzed individually. But I would say, well, if they said something about Bitcoin specifically in depth with the way that they arrange things, yeah, it could be helpful for XRP or for Ripple's defense, right? It could be. And that's once more why we're all thinking that they decided to leave this out. Why they're trying to defend right now that they shouldn't give over the documents, partially because it's a ton of freaking work. It's most likely tens of thousands of documents and some very confidential information. Yeah, I could definitely get that. But in the end of things, Ripple also wants to defend something, and well, XRP and Bitcoin are the only two coins that used to be above XRP before they got sued. So it's not really crazy that they want to have some info about those because they've been properly regulated. So then Ripple can see for themselves what the differences are and how they arranged for those ones, since Ethereum and XRP are really not that different, even though you might think so. They really aren't, especially if we're talking about inception, and especially if we're talking about the way that things were handled before a couple of years ago, before the real use case was actually there. Then here, defendants effort to obtain discovery from SEC as to Bitcoin and Ether, and noted that if the defendants were confused about the requirements of Howey test, they can make an argument objectively about that specific thing. That's again for kick. Nor is Ripple's argument that XRP is not a security because the Financial Crimes Enforcement Network Bureau of the United States, FinCEN, designated XRP as a virtual currency. We've already seen before that FinCEN can label something as a currency, yet the SEC can still label something as a security, and the IRS can label something as a commodity. So we don't have to go further into that one either. It's just another statement here that, again, their statements themselves don't matter. Now let's move on a little bit to point number 4. The requested documents concerning the SEC's own views about XRP and Ether and Bitcoin are not relevant either. So in my belief, document 3 is basically the official verdict, the requested Bitcoin and Ether documents. So the verdict of the documents and basically what happened there. And number 4, once more, this is just my opinion, I'm not an attorney, not a lawyer, not anything, is what the SEC has basically discussed about XRP, Ether, and Bitcoin, but mostly just XRP with other people. You know, so what have they said about it? What is their relevant? And I also, if I'm just reading this point here, even reading it out to you guys now and explaining what I think, it sounds really strange, right? It sounds really, really strange. As detailed above, the key question in this litigation are whether XRP is an investment contract under Howey test, whether defendants offered and sold unregistered securities not exempt from registration in violation of Section 5, and whether Garlinghouse and Larson aided and abetted Ripple's violations and committed additional violations through their own sale of XRP. Defendants ignore these legal principles and try to shift blame to the SEC by claiming they lacked fair notice that XRP could be securities, including by claiming they received no formal guidance that Ripple sales may be illegal. So in this case here, what I would like to say is the SEC is just defending their part again, saying it's a question, all right? The key question in this litigation are whether XRP is an investment contract under Howey test. What they're saying here is it's not been decided. So a fair notice, theoretically speaking, could not have been given as it's a question. So why, right? They're saying that Ripple's trying to shift the blame to the SEC for not giving it, but there wasn't anything necessary because it's a question now still. There's no judgment being made. And also, letter at 2, but the law does not require the government to reach out and warn all potential violators on an individual or industry level before bringing suit. As noted before, the SEC has provided guidance, including guidance that Ripple and Garlinghouse were aware of. Instead, under the Securities Act, the SEC may, in its discretion, bring an action in any district court of the United States to enjoin any violations of security laws. The Act separately gives the SEC discretion to issue regulations with respect to a variety of provisions, including, as relevant here, to issue certain regulations to determine which transactions are exempted from the registration requirements of Section 5, see USC, yada, yada, yada. Defendants' argument that the SEC must give formal guidance to each potential violator before exercising its statutory discretion to enforce the security laws through a civil action such as this one is a requirement that does not exist. And I get that. I get that. However, the point here, in my opinion, is they said it is not necessary, right? So then again, we can bring up the point. So why, when Coinbase was discussing it with the SEC, did they have to delist it? Because this once more tells us that the SEC did not know at the point of suing. Otherwise, why would you also not get, like look at this. The SEC here says they don't have to give this legal notice to these exchanges, for example. But why wouldn't you, right? Why wouldn't you? If your interest is to protect investors, then, and you've been investigating Ripple for 8 years, why don't you give these exchanges a head up if that can save a ton of investors from buying investment contracts, is the way that I like to put it. Why would you not? They're saying we don't have to. Okay, but why wouldn't you then? If that's your best interest, then why would you not do that? And also, it is really odd, in my opinion, that they haven't warned exchanges, yet Ripple, and specifically Barrett Garlinghouse and Chris Larsen, should have then known that it was the case, that it was already an investment contract from the start. They're basically pointing out a couple of times that the SEC has provided guidance, including guidance that Ripple and Garlinghouse were aware of, and I'm not sure exactly what that refers to. I'm not sure if this refers to guidance surrounding what a security is or guidance for what to tell exchanges or what exactly, but it does also really kind of not sit right with me. The way that this is all moving along is just very odd. Moreover, the views of any of the SEC commissioners and staff as to whether XRP or other digital assets are investment contracts, particularly while in the process of gathering information to make a recommendation regarding enforcement of the security laws as to XRP, are entirely irrelevant now that the staff has completed its investigation and the SEC itself has authorized the enforcement action. This is basically a negative thing for Gary Gensler, people saying, oh, he's going to really fix everything. It says here that the opinions of the SEC members specifically don't matter anymore now that this lawsuit has been filed. I would also like to disagree with that, but right. Statements of agency staff cannot bind the SEC or otherwise alter its decision. I would once more like to disagree with that. But statements by individual IRS employees cannot bind the Secretary of Treasury. I would agree with that partially, though. And nor are the SEC's views as to the treatment under Howey test of other digital assets relevant to whether XRP is a security. I would say that's a lie. I would say the SEC's views as to the treatment under Howey test of other digital assets is extremely relevant to XRP's case. I don't know how they try to make up this argument. I would think, again, once more, I'm just a normal citizen here. I would think if a judge sees this little part saying that, oh, you know what, the SEC decided for any other Howey test case with other different digital assets is not relevant. Of course it is relevant. This is like the most strange argument I've ever seen in my life before. It sounds extremely logical that every other case and what the SEC has decided in that regard, specifically regarding Howey tests, would also fall here. If they, for example, said in a lot of other digital asset cases that, okay, yeah, that is all security-ish, but this one isn't, then and then we're talking about XRP, which is different digital assets, and they're like, okay, but that one in this case, it actually is. It might be the exact same thing. Hopefully you guys got that one where in a previous case, they might have stated that something is not security worthy because of one specific point. That might overlap with XRP, we don't know, because we're not getting their views. And I would say it is very relevant because, well, you got to be consistent in your views as well, right? As Judge Hellerstein held in rejecting a digital assets issuer request to conduct the same discovery defendants now seek. However, that was, of course, a much smaller investigation, in my opinion, than this one. Including internal and external SEC communications about Bitcoin and Ether and other digital assets, the deliberations within the agency shed no light on the application of the statute or regulation and issue. If the law is vague or confusing or arbitrary, as defendants argue, then that can be argued objectively. Proper discovery should be focused on what defendants did and not why the agency decided to bring the case. I would say it doesn't really matter why they brought the case, because in the end of things, you can always argue that they're trying to figure out whether or not it is a security, so I don't really doubt that. I more so doubt in the way that they're judging it right now, because I would say there's no objective answer to the question, is XRP an investment contract, or has it been sold as an investment contract rather? So having the SEC's views on it actually, in my opinion, does matter, because that could show some inconsistencies. Defendants correctly recognize that whether an instrument constitutes as an investment contract within the Securities Act depends on what character the instrument is given in commerce by terms of the offer, the plan of distribution, and the economic inducements held out to the prospect. But defendants wrongly assert that the SEC itself has helped shape the character of XRP in commerce. To the contrary, the SEC does not give character to instruments in commerce by issuing terms of an offer, setting forth a planned distribution, or holding out economic inducements to prospects. Rather, the legal focus should be squarely on what Ripple, the issuer, promoter, and responsible steward of XRP, and Garlinghouse and Larson did to offer and sell XRP. Interesting here is that they never talk about the previous founders, right? In this case, they're talking about Ripple, but I don't believe that Jim McCaleb is ever actually mentioned, even though he's a co-founder of XRP and of Ripple. And it also does not matter what the biggest holders of XRP have ever done. You know, in theory, if there was a big holder of 20 billion XRP, then this whole case would have kind of fell apart, right? Because, for example, there could be one, I'm not going to say majority, but a major holder who has a lot of influence, or even if this network were to be centralized, because you'd have a couple of cartel forms, basically, where a couple of validators were to come together, and basically the unique node list is not as decentralized as it kind of seems. I would say that's quite interesting, or as separated as we thought. I would say that's quite interesting because they're only referring to Ripple themselves, only to Ripple, and only to Brad Garlinghouse and Chris Larson from within Ripple specifically. Indeed, defendants point to no case that accepts their theory that to apply Howey, a court must probe into the communications of the agency charged with enforcing it, and the SEC is aware of no such case. I'm not sure about all of that, so I cannot say. Nor can internal SEC views of the status of XRP, Bitcoin, or Ether be relevant to the individual defendant's signature. Now, this one is also one I would like to argue because I'm not going to go too much into depth because there's still a couple of questions I have that will be answered hopefully soon by some attorneys. If you think about it, the way that the internal SEC views the status of XRP, Bitcoin, or Ether can actually be very relevant to anything regarding it. Even the defendant's individual signature or Skynter, I'm not sure how you guys pronounce it, whatever. Because think about it. If the SEC internally thinks very positively or very negatively about something, it's going to also out itself differently, right? Or one person within the SEC might fight for the opposite, or might actually recommend against it, or might even not bring up the case at all, or might not bring this at all. You might say, okay, but now that they have fought it, it doesn't matter anymore. That's some argument that you could make. However, from the start, it is very relevant to see if the Bitcoin/Ethereum verdicts were biased, and were they not given a little bit more of a easy treatment because of bias from within the SEC. Like, would the same exact question be asked about XRP and Ether or not? And does it have to do anything with the bias from Bitcoin and Ether from maybe a connection? Which we saw a little bit earlier. We saw some videos. I also shared it over on Twitter, I believe, somewhere. Just check through it somewhere. You'll find it. There were a couple of documents which I thought was really interesting regarding Ethereum specifically. I'm not sure exactly where it is. John Deaton also tweeted it out somewhere. And that mostly refers to the fact that there's a lot of Ethereum connections within the SEC. There's a lot of Bitcoin connections within the SEC. So are they biased, yes or no? And then the B part here was defendants cited laws does not support their requests. Okay, but let's just leave it at that for right now, right? There's more even, but we can leave it like this for right now as it goes on and on and on and on about explaining why it's not relevant, why it's not the case. Let me see, where's the next here? You can see document number 9 and number 10. However, it concludes to defendants' requests are disproportionate, overbroad, and unduly burdensome. And I get it partially because, once more, we are most likely talking about tens of thousands of documents, thousands of emails, a lot of freaking work to put it all together. And the question is, of course, from the SEC's perspective, will Ripple find something which is going to kind of provide the contrary? I'm thinking they might find some bias, which could be very freaking scary. They might find some different treatment. And look at this last part right here, right? Defendants request that the SEC search 19 custodians. We said it at the beginning, but hey, for both internal and external documents and for documents related to Bitcoin and Ether would impose a disproportionate burden on the SEC to review a massive number of relevant documents. Specifically, a search to determine the number of responsive documents held by 16 of defendants' 19 proposed custodians, excluding the SEC commissioners, found the following number of search hits for external communications: 29,754 for Bitcoin or BTC, 10,900 for Ether or ETH, and 6,364 for XRP or Ripple. XE, Declaration of Martha Mitchell. The SEC should not be forced to review and produce tens of thousands of irrelevant documents. I'm also thinking, why would they have to review it? They could just give it all over, right? Why would they have to review anything? If there's Bitcoin inside, it could be relevant already, theoretically speaking. Such a result would be entirely inconsistent with Rule 26 relevance and proportionality requirements. Instead, the SEC should be allowed to proceed with its agreement to search the 9 custodians most likely to possess responsive documents related to XRP and Ripple. That, of course, is already a start, though. Second, much of the discovery sought by the requests is protected by one or more privileges or protections, and reviewing the vast number of documents covered by the request to determine which are privileged or protected would be extremely burdensome. And that's, again, where my first argument, of course, not lies. I knew that was coming, which is that there are some protections and there are some things you just cannot share, I'm assuming. Now, one kind of counter-argument, of course, to that one is it's the freaking U.S. court. It's the government suing Ripple, a multi-billion-dollar company, so a lot of things can be brought on the table if necessary. Yet there are, of course, some protections in what you might want to and might not want to share. I'm not too aware of those rules specifically, but I know they must be there. They must be set in place, and thus they would have to look through all the documents to know if they could give or not give that, which definitely is a very burdensome task. It would definitely extend the lawsuit by a good amount because, I mean, a judge could also see if they all of a sudden have to go through tens of thousands of documents, it might take longer for them to get all the information. I'm not sure if those dates can actually be shifted. I'm assuming they can if both parties agree, though. Several of the requests seek information covered by the deliberative process privilege and the attorney-client privilege, but the decision-making process of a government agency are protected from discovery by the deliberative process privilege, as the Supreme Court explained earlier this month. Question is going to be, in the end of things, will Ripple be considered right or not? That's all I can say for right now. Let's just wait and see. I'm definitely quite interested. I don't even know what this document here is even. I didn't read this one. Ooh, there's a Exhibit D. Okay, so wait, let's quickly see. This was SEC v. Ripple, SEC opposition to letter of motion to compel, filed March 22nd. Then here is SEC letter requesting sealing of certain exhibit. Okay, I didn't even read this one. I didn't know that that one was there. Let's quickly see. Via EC, oh no, this is just a one-pager by George or Jorge. And then this one is Exhibit D. I'm not sure what that stands for. If you know, let me know in the comment section down below. Once more, I have no freaking clue. All right, I should have read it before then. Let's not read it right now, though. It talks about the Howey test. I see a couple of times here. Somebody says Jorge quit. Now it's Dugan. Is this a different attorney that put this one up? Not sure. We should see that at the start. But this is something completely different. However, it's also filed today. Yeah, I'm not too sure, guys. Let's this is buy securities, okay. No, I'm not sure. Let's not cover this one because I'm not sure what this one is all about. Here, this is still to Sarah Netburn, the preliminary judge. Is that the thing you guys call it? I often get that one confused. This one also refers to Ripple, I see. Did I read this one? Not sure either way. No, I didn't read this one either. But yeah, you guys get the picture, right? Oh, it's a freaking 30-minute video already. No way. Ooh, so I guess I'll skip out for the talk about the price and what I thought was going to happen. We'll talk about that a little bit later. Yeah, it's already been 30 freaking minutes, so let's cut it short here. See you guys again in another crypto video. I think this is all BS. I think in the end, though, Ripple is obviously going to win it. SEC has definitely got something to hide, but it's a matter of time before we find out exactly what it is. All right, so that was it for today. Hopefully you guys all enjoyed it, and I'll see you guys again in another crypto video. Let me know down below what you think about the whole case and about the whole situation. Do you think the SEC is hiding something, or do you think that it's in their fair right to try to hide it?